Field of transitional justice, and that's the field that's concerned with how we address human rights violations, past human rights violations in countries transitioning out of conflict and hopefully transitioning towards democracy. This field of transitional justice is quite new. It's only in the last 20 to 25 years that it's said to have come up. And it's often been characterized as having at the heart of the field a tension or a debate between peace and justice. What comes first? Which is more important and should be prioritized, particularly in a context where the threat of prosecution, i.e. justice, may in fact prolong the conflict and as a result lead to further human rights violations. In this debate, which in a crude fashion suggests that there is somehow a necessary tension between peace and justice, the danger is that we are actually reducing the very notion of justice to being solely about trials, and the notion of peace as being solely about negotiation processes aimed at stopping the immediate bloodshed. Neither of these definitions is appropriate to the pursuit of human rights, human security, or put another way, positive peace and social justice writ large. And related to this question is again, who gets to define what justice means? If we're securing justice for people on the ground, in the context of these conflicts, should the value not then be locally informed? And I give you the example of Rwanda, again, with the International Criminal Tribunal for Rwanda, based out of Arusha after the genocide. Millions of dollars has been spent every year since the genocide on prosecuting a handful of genocidaires. And this is not to say that that this was not a necessary measure, that there needed to be some accountability for those who initiated, planned, and propagated the genocide. However, there's a disparity between the millions that have been spent on this international tribunal and the views on the ground of regular Rwandans. And the views on the ground of regular Rwandans are the people who perpetrated this genocide and instigated these atrocities are living in plush cells with 3 square meals a day and access to antiretroviral treatment if they're HIV positive, whereas their victims are living in poverty, many of whom have died of AIDS as a consequence of the crimes that were perpetrated against them. And so we must remember that justice is both subjective and objective, that it very much is also about perceptions of justice by victims. The first is the issue of deterrence. It's said that if we do not prosecute, if there is not accountability for people who perpetrate such mass atrocities, that these atrocities will continue in future. In effect, there isn't really any evidence of the impact of criminal prosecutions at an international level. The one example that I can think of is that some of the worst atrocities in the former Yugoslavia took place after the ICTY was up and running. So the argument of deterrence is largely an untested one. And a related argument is the issue of impunity, that it's morally wrong that people who perpetrate these atrocities are allowed to go free. The reality, however, is whether prosecuted or not, these crimes will go unpunished. In a context of long-term and mass atrocity over 20 years in northern Uganda, there has only been 5 warrants of arrest issued. The vast majority of these crimes will not be prosecuted and will not be addressed by the International Criminal Court. I also don't ascribe to the view that's often voiced that the ICC intervention in Uganda has done damage to the peace process in Uganda. I think that those who support this position can find evidence to support it. There is, however, equally evidence that the indictments have encouraged more people, more rebel soldiers to approach the Amnesty Commission. The Amnesty Commission was an institution that was set up in Uganda to demobilize rebel soldiers, reintegrate them back into communities. There's also an argument to be made that the ICC warrants of arrest gave impetus to the Juba peace talks, which was the latest round of peace talks between the government and the LRA, which have, at the moment, I understand, broken down. And there's rumors that the LRA has fled to the Central African Republic. But for me, the point isn't the impact that the ICC indictments have had on the peace talks or on the peace process, whether they've been an obstacle or an impetus to the peace talks. The point, again, is what justice we're advocating and for whom. So as noted earlier, the debate in Uganda has been polarized not just around the question of whether to prosecute or not, but rather a polarization between local mechanisms of justice versus the International Criminal Court. In recent years, a number of well-meaning civil society groups in Uganda have begun advocating for the use of traditional justice practices as the road to peace and justice. Much of this advocacy revolves in particular around a particular traditional practice called mato put, or literally translated as the drinking of the bitter herb, I believe is the translation. And I'm not going to give you much of a background of mato put, except to say that it is a traditional justice mechanism that was employed in the wake of homicide and was employed between clans in Uganda, in northern Uganda specifically. And some have been advocating that mato put would satisfy principles of accountability as demanded in the Rome Statute, and that the International Criminal Court must then leave Uganda, as it would no longer have a mandate there. If accountability is achieved at a domestic level, the International Criminal Court is no longer has a mandate within that country. So as I did with the arguments of the justice camp, I just want to address some of the weaknesses and problems with the so-called peace position. And the first of these is that it proclaims to draw upon traditional African notions of forgiveness as a shared value. And in reality, there is no such common shared African value of forgiveness. And I just want to give you an example. In recent months, I was in Liberia working with a civil society organization, having some of these conversations around their Truth Commission process and issues of justice and peace in Liberia. And one of the local members of civil society there stood up and said, you know, this idea of an African value of forgiveness, which to some extent I actually sadly think has come largely from the South African Truth and Reconciliation process, where the notion of forgiveness was put up on the world's screens as being an African notion of Ubuntu and forgiveness and reconciliation. And he was saying that, you know, in Liberia alone, there's 18 different ethnic groups. And each of them has their own views of justice and reconciliation. And for some, an eye for an eye and retributive justice is their notions of dealing with acts that are not sanctioned by society. In Uganda, a survey was conducted a couple of years ago in which over 80% of respondents stated that they wanted to talk publicly about their experiences of violence. And when asked about their needs, most victim communities talk of immediate needs of food and peace. And peace because it was a necessary prerequisite to development, which is itself an essential element of both positive peace and holistic justice. And so the needs of victims have been voiced as being acknowledgement, truth, reparation, and accountability. And none of these can be achieved through the mechanisms that have been proposed so far, at least not exclusively through mato put, not exclusively through the Amnesty Commission, and certainly not exclusively through international prosecutions.